everyone, welcome to Law Simple, Pure and to the Core. Dr. Vaishali here. Today's topic of discussion is Theory of Separation of Powers or Doctrine of Separation of Powers. In our legal curriculum, two doctrines are very important, and those doctrines are Doctrine of Rule of Law and Doctrine of Separation of Powers. As I told you earlier, in law, things speak for themselves. So, if a word is there in front of you, you have to interpret it literally. So, what is the meaning of separation of powers? Powers should be separated. What is the meaning of rule of law? Law rules, right? So, why power should be why power should be kept separated? Because as provided by Lord Acton, power corrupts and absolute powers corrupts absolutely. Then the next question comes is, which types of powers must be kept separated? So in any state or in any country, three types of powers are concerned or considered as most important powers, and they are lawmaking powers, law implementing powers and adjudicating powers. So these three types of powers must be kept separated. If these powers are separate, then there will be no autocratic type of rule or there will be no chaos in the country. Origin of the concept. As you all know, in our constitution, lots of principles are derived or taken from the constitution of other countries like USA, UK, France, Ireland, and so Canada and so on. So the theory of separation of powers is taken in Indian constitution from the US constitution, and theory of rule of law is borrowed from the UK's law. So origin of the concept for us is it comes from United States, but in general this theory is propounded in 1748 by a French philosopher called Montesquieu in his book The Spirit of Laws. But even before Montesquieu, it is propounded by English philosopher John Locke that legislative power should be divided between king and parliament. So he said that powers of king and powers of parliament must be kept separated. And even before John Locke, Aristotle provided for separation of powers indirectly. So what is the meaning of separation of powers? There are three types of powers in any country, and that is legislative power, law implementing power or executive power, and the third is law adjudicating power. These three powers must be given to three different organs of government, and these powers should not be concentrated in one single organ of the government. So that is the theory of separation of powers on paper. So let us see what happens in UK and USA and India, that is the comparative aspect of our theory. So let us go through comparative aspect of our theory quickly. Speaking about United Kingdom, as we all know, cabinet system exists in United Kingdom, and existence of cabinet system refutes or never allows the doctrine of separation of powers completely. It is the cabinet which is the real head of the executive instead of the crown. It initiates legislation, controls the legislature, and it even holds the power to dissolve the assembly. The resting of two powers, that is executive and legislative, in one single body therefore denies the fact that there is any kind of separation of powers in the United Kingdom. But yes, judiciary is independent in UK, and theory of separation of powers is partially applicable in United Kingdom, but it is never fully accepted on paper. Next country which is in line is United States. The doctrine of separation of power finds its home in the United States. It forms the basis of the American Constitution. And do you know, American Constitution begins with separation of powers. Article 1 vests the legislative power in the Congress, Article 2 vests executive power in the President, and Article 3 vests judicial powers in the Supreme Court. So yes, theory of separation of powers is there in United States, and theory of separation of powers is not there actually provided on paper in United Kingdom. So let us see what is the status of this theory in India. Theory of separation of powers is there or it is applicable in India. Indian Constitution by Article 50, which is a directive principle, puts an obligation on states to take steps to absolutely separate the judiciary from the executive. But again, directive principle is, as you all know, it's not enforceable in the court of law. Afterwards, executive power of the union and state is vested by the constitution in the president and the governor respectively by Article 53(1) and 154(1). But there is no corresponding provision vesting the legislative and judicial powers in any particular organ like it is vested in judiciary. But again, it is implicit in lots of articles of the constitution. So let us see what is the actual situation of this theory in India. Is it applicable fully? Is it applicable partially? Or it is diluted so as to suit the Indian conditions? So let us see what happens in India. As far as executive department is concerned, let us see whether there is actual separation of powers or not. The executive in India is a part of legislature. It is responsible to the legislature for its actions and also it derives its authority from legislature. The executive power vests in the president, but in reality, he is the only formal head and we all know that. The real head is the Prime Minister along with the Council of Ministers. The reading of Article 74(1) makes it clear that the executive head has to act in accordance with the aid and advice given by the cabinet. So yes, there is a mixture of power as far as executive is concerned. Going ahead, under some specific situations, executive can have legislative and judicial power. How? Under specified circumstances, president is also empowered to exercise legislative functions, like while issuing an ordinance, framing rules and regulations relating to public service matters, formulating law while proclamation of emergency is ongoing or it is in force. These are some instances of executive doing some legislative types of functions. Again, executive have some judicial functions also. President performs judicial functions. Article 72 empowers the president to power to grant pardon, reprieves, respites or remission of punishment or to suspend, remit or commute the sentence of any person convicted of any offense. So power to grant mercy is also there, which is a judicial power. So executive is the department which performs all the executive functions, but some legislative and some judicial powers are vested in the executive department by the constitution itself. Now let us see what happens in legislative department. As far as legislature is concerned, Parliament also exercises judicial functions. While performing judicial functions, it can decide the question of breach of its privilege and if proved can punish the person concerned. While doing so, the Parliament is a sole judge and courts cannot generally question the decision of the houses on this point. Moreover, in case of impeachment of the president, one house of the parliament acts as a prosecutor and other house investigates the labeled charges and decides whether they are substantive or not. So yes, legislature performs some judicial functions. Now the head of executive is the president, but a closer look shows that he is only nominal head and the real power vests in the prime minister and the cabinet of ministers under Article 74(1). So right now we are sure that executive performs some legislative functions and some judicial function. Similarly, legislature also performs some judicial functions and some executive functions. Now let us see what happens in judicial department. In India, we have a hierarchical type of judicial system. So courts are arranged in hierarchy. At the apex level, we have Supreme Court. Below Supreme Court, there is a High Court. And then below High Court, there are other courts like Sessions, District Court and the other courts. So as far as judicial wing is concerned, again there is a dilution of the theory of separation of powers. The High Court and the Supreme Court has been given the power of judicial review and they can declare any law passed by the Parliament as unconstitutional. So while doing that, they are encroaching upon the power of legislature. The judges of Supreme Court are appointed by the President in consultation with the Chief Justice of India and judges of the Supreme Court. Supreme Court has a power to make rules for efficient conduct of its business, which is again a legislative function. Judiciary in India can perform some executive functions also. When it supervises all the subordinate courts below, it has legislative power. It is doing executive powers. It has certain legislative powers also, which is reflected in formulation of rules regulating their own procedure for the conduct of disposal of cases. So far we have seen that every department performs functions of the other departments. Executive performs certain legislative and certain judicial functions. Legislature performs certain judicial and certain executive functions. And again, judiciary performs certain executive and certain legislative functions. So that's the reality in India. Now let us see the theory of separation of powers or application of this theory through certain concrete case laws. Please try to note down the cases on separation of powers. So first case on this matter is Ram Javaya versus State of Punjab. The court, Mukherjee court was there, or Mukherjee just held that Indian constitution has indeed not recognized the doctrine of separation of powers in its absolute rigidity. But the function of different departments or different parts of or branches of government have been sufficiently differentiated, and consequently it can very well said that our constitution does not contemplate assumption or usurpation by one organ or part of the state of functions that essentially belong to another. So Justice Mukherjee confirmed that though it is not specifically provided in our constitution, constitution intends that every organ of government should remain in its limit and should perform its own functions and should not encroach upon the functions of other part of the government. Next case in the line is Kartar Singh versus State of Punjab, where Ramswamy Justice stated that the basic postulate under the Indian Constitution that the legal sovereign power has been distributed between the legislature to make the law, the executive to implement the law, and the judiciary to interpret the law within the limits set down by the Constitution. So Kartar Singh versus State of Punjab confirmed the situation or the fact which was provided in Ram Javaya versus State of Punjab. Now let us see what happens in next case. The next case is a reference in Red Delhi Laws, Supreme Court. Justice Kania observed, although in the Constitution of India there is no express separation of powers, it is clear that the legislature is created by the Constitution and detailed provisions are made for making the legislature pass laws. Does it not imply that unless it can be gathered from the provisions of the Constitution, other bodies, executive or judicial, are not intended to discharge legislative functions? So Kania Justice confirmed the facts provided in Ram Javaya and Kartar Singh, that though it is not specifically provided, it is everywhere in the spirit of Constitution that every organ should remain in the limits of power conferred on it by the Constitution. Next case is Keshwanand Bharti, which went one step ahead and Beg Justice added that separation of powers is a part of the basic structure of the Constitution. So far, theory of separation of powers was not a part of basic structure, but in Keshwanand Bharti, Justice Beg specifically provided that theory of separation of powers is a part of basic structure of the Indian Constitution. So Parliament can amend the Constitution, but Parliament cannot amend the basic structure, and separation of powers is a part of basic structure. So Parliament cannot amend or change the theory of separation of powers, and it officially put the theory of separation of powers beyond the legislative ambit. So now we can say that after Keshwanand Bharti, that separation of powers became an integral part of the Indian law. Next case in line is Indira Gandhi versus Raj Narayan. Supreme Court confirmed the principle of Keshwanand Bharti's case and provided that basic structure doctrine is a part and parcel of Indian Constitution and theory of separation of powers is a part of basic structures. It was held that Parliament cannot under any constitutional amending power or the like take on the role of the judiciary. So Parliament cannot take the role of judiciary while trying to amend the constitution. The position of separation of powers was upheld and asserted in this case once again. So these are the case laws. You have to provide each and every case laws in your answer for getting good marks, and afterwards try to discuss this point in your answer sheet. Welfare state and theory of separation of powers. As you all know, when India got independence, India was a police state. In police state, state performs function of maintaining peace and order in society. But now it is a welfare state. In welfare state, state performs lots of other functions than a police state. State performs sanitary facilities, state provides for good roads, state provides for good schools, state takes care of education, state takes care of environment and like pollution and all those factors. So pretty much each and every aspect of human life is supposed as a responsibility of state in welfare state. So in welfare state, functions of each organ of government, they have increased like anything, and it is highly impossible to perform their functions in this strict doctrinal jacket of theory of separation of powers. Powers of legislature or functions of legislatures, they have increased, and they have to delegate some part of their work to some other organs of the government. Similarly, now, earlier government had very few departments. Now those departments have increased like anything, and government or executive cannot perform each and every function, and that's why executive is giving that work to certain other departments also. Similarly, as you all know, judiciary is overburdened, and that's why there are some other mechanisms like arbitration, conciliation, and so on. So theory of separation of powers is diluted to a great extent by the concept of welfare state. But again, it is a necessity of time, and for the betterment only this is happening. So you can conclude the answer like in India we do have a theory of separation of powers. It is nowhere directly written or provided by the constitution, but it is there in the philosophy of constitution, or you can imply it from the reading of the constitution. We have taken it from the United States, and then you have to conclude that it is not strictly applicable. These organs do not work in watertight compartments. Water flows from one department to another department, and theory of separation of powers is diluted to some extent, but it is still followed in India. So that's it for the day. Stay tuned till my next lecture. Goodbye and good luck.